Well, hello there. How is everyone on this fabulous midday hump? That's right, baby. It's the midday hump. And you're looking amazing, by the way. Let's see if you can hold it out for the rest of the week. So, look, I put up a poll yesterday, and a lot of you said that you wanted me to go through the documentation. I appreciate some of you have already heard some of this documentation now, because you're impatient little buggers, like me. So this will be old news to some, but it will be in my dulcet tones. Look, I might not be as good looking as that sexy beast over at Law, and I'm not a professional either. But, look, some of us can make reading the phone book sound cool. So we're going to go through some docs. There is a new one at the end regarding court TV. Let's get straight into it, shall we? So what do we got? As he learns how to press buttons. Whatever's going on here. I pressed the wrong button. There we go. Learn how to use your stuff. So this is the first of 6. Some of the documents aren't actually that long. This is literally just a notice of hearing, which is the September 1st hearing at 1 p.m. Motion to remove cameras from the courtroom. I think we can scrap that one, can't we? We know what that is. So the second one, what do we got here? So we've got in the District Court of the 2nd Judicial District of the State of Idaho in and for the County of Latah is the defendant's 7th, I repeat 7th, supplemental request for discovery. How many times do you see a court case where they literally have to ask for something 7 times? You know what? If Mrs. Harsh had to ask me to give her something or do something 7 times and I still hadn't done it, I'm telling you what, I wouldn't be writing, and I certainly wouldn't be going to the toilet without discomfort. So look, please take notice that the undersigned, pursuant to Rule 16 of the Idaho Criminal Rules, the 4th, 5th, 6th, 8th, and 14th Amendments to the Constitution of the United States and Article 1 and 1, 2, 13, 17 of the Constitution of the State of Idaho request discovery and inspection of all materials discoverable by defendant per ICR 16B 1 through 8. And the aforementioned constitutional provisions, including but not limited to the following information: evidence and materials outlined in Exhibit F. Now, I don't think, let's just come out of that, I don't think that can be any straightforward, can it? They're basically saying, look, everything that we are entitled to in accordance with the law and our constitutional rights, can you please give us it? Because we keep asking and you're not giving us it. Just get on with it. This fucking gaslighting. And next doc, what do we got here? So this is a stipulated motion to file Exhibit F attached to the defendant's 7th supplemental request for discovery under seal. Comes now Brian C. Koberger, by and through his attorney, Ann C. Taylor, public defender, and hereby moves the court to an order to file Exhibit F of defendant's 7th supplemental request for discovery under seal. This motion is made pursuant to ICAR 32I 2D and E. We won't read them numbers. The documents contain facts or statements that might threaten or endanger the life or safety of individuals. It is necessary to preserve the right to a fair trial, and disclosure would constitute an unwarranted invasion of personal privacy. Now I don't know, someone might be able to tell me whether that is just generic verbiage, where they're just saying, look, we want to file something under seal, and when they do so, they automatically use specific reasonings behind it. But then I think to myself, but hold on, surely you couldn't say, I want to seal this, I don't want anyone to see it, because someone could die because if someone sees that we're talking about it, because that's what it comes across. That comes across to me like they're trying to say, look, we need to talk about something, and by talking about this, if someone catches wind of this in the public, because that's ultimately who they're hiding it from, the public eye, someone could be put in risk. But which further, in my opinion, my non-professional opinion, that further feeds into these thoughts and feelings that people have around this case, such as, is there a cartel sort of angle to it? Is there other people involved in this crime? And are certain people who have left the area and not come back done so in fear of doing so? Do you know what I mean? And it's these little things that feed into that narrative when you're hearing stuff like that. And I would just like to know whether there is any sort of, how can I say? Like I say, is that verbiage just standard? And if it is standard, then how do they get away with it? Because you could just turn around and say, look, we don't need to put this under seal because what you're saying is just generic verbiage and it's not relevant here. It's not viable. No one's going to die because you're talking about Aunt Susan. Anyway, I digress. So that is that one. So we go to the next one. We're getting through them. We're rattling through, baby. We're rattling through. Right. Order to file Defendant's Exhibit F attached to the Defendant's Evidence. I think this is pretty much the same thing. Just it is agreed that will be filed under seal. So again, if it was just generic verbiage and there was no value to what they were saying, surely they could turn it down and just have it out there for all to see. Next, order extending time to respond to defendant's motion to dismiss indictment and continuing hearing. Makes you laugh, doesn't it? That what you've got here is this is now the state saying, oh, you've now given us a load of stuff to read. Well, we now need more time. Whereas Brian Coburg was like, well, you can't have more time. We can't pause this. We can't do anything, and put him in a position where he then has to rescind his rights to a speedy trial in order to give them the time to go through their shit. And these are now asking basically for time. Based on the state's motion to extend time to respond to defendant's motion to dismiss his indictment and to continue hearing filed hearing on August 24th, 2023, and there being no objection from defense counsel, the court does hereby order that the state's response to the defendant's motion shall be filed no later than September the 14th. That's 13 days after the September 1st hearing. And the defence reply filed no later than September the 20th. So it does still sound like they're trying to push this through. So even though we was in kind of fear that once the speedy trial situation had come into play, that we could potentially be looking at years down the trot. But there is still being specific deadlines, and they're all being sort of closely pulled in. So perhaps we'll still see a relatively speedy trial if people start pulling their finger out. The court further orders that the hearing set on September the 1st, 2023 is vacated and reset to commence on the 26th. I should have seen this first, shouldn't I, before I said about the September the 1st. So basically, they're going to vacate that hearing and everything's going to be heard on the 22nd at 10:30 a.m. So there's a date for your diary. We don't need to see that. Which brings us to the last doc, the sixth, the final doc, which is basically, this is court TV. This was court TV saying, look, we rarely, I don't even need to show you, I'll basically tell you, court TV approaches a court, they say, look, we rarely want to bring cameras into your court, and we promise to abide by the rules. We promise that despite the fact that in the past, I know we have done documentary series on Brian Coburger and twisted it to make him look like he's guilty before he's had a trial, and we've put some very, very damaging stuff out on the intranet. Ignore all that, because now we're going to play by the ball. We're going to play by the rules. We're going to play ball. We're going to behave. And the court turned around and went, fuck off. there you have it. That's the docs in a nutshell. Love you all, and I will catch you all in the next one.